Right from the start, we're stepping into a Nelson hearing, which is basically when a defendant asks the judge to fire their court-appointed lawyer. These hearings can get tense fast, because the judge has to decide if the lawyer is actually incompetent or if the defendant simply doesn't like the advice they're getting. And you're about to see exactly how that clash unfolds.
Your Honor, this is Mr. Dougherty in case 250045, and we're here for a Nelson hearing.
Mr. Dougherty, if you'll raise your right hand to be sworn.
I solemnly swear the testimony you're about to hear is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, sir, state your name.
Jerry Doherty.
Mr. Dougherty, what are you asking for today?
Your Honor, I appear before the court to express my serious concerns regarding my current legal representation and the handling of my case. I have repeatedly asked the attorney to file a motion of dismissal based on evidence of two individuals involved providing false statements in their police reports. They both are fully aware that my son was 21 at the time. She adamantly said he was 16 over and over to the police to insist that I be arrested.
This is a classic move in Nelson hearings. The defendant lists every issue they believe proves poor representation. But here's the legal catch. Even if witnesses lied or evidence seems wrong, that doesn't automatically mean the lawyer did anything improper. The question is whether the attorney failed in their duties, not whether the defendant disagrees with the evidence.
Despite this request, she says she's speaking for you. I don't know if this was something you said or not, that you would refuse to dismiss it, is what I was told. That you would not dismiss it, that it would not change anything, that she lied on the police report. She even just recently, she just did the depositions. And it also turns out that she did lie again under depositions. Officer Sanders also has spoken to her assistant and knows that she's lied. She's also has a warrant out for her arrest for theft of my property. She stole all my items inside my home, sold them at pawn shops. They have her on video footage. And I've asked Miss Beasley to please explain. She cannot explain to me why this continues. She just shrugs her shoulders and says, okay, it is what it is. It just continues on. And I don't understand, and I can't get her to submit with me in writing why these charges are continuing, why her lying is being admitted and just shunned under the rug when they know this is true. And my son, he was coerced in the lying. On the police report that you have, if you look at his age, you can see it's like, it almost looks like it should be 2003.
And there it is. The judge draws the line. Legally, judges cannot replace a lawyer just because the defendant thinks a witness lied. That's a jury issue, not a dismissal issue. The judge is signaling that this argument won't get him a new attorney, and tension is definitely rising.
It looks like it was made into an 8. I've asked to look at the evidence as far as the video footage. And when I went to go review it, it starts off with the police officers behind my couch, lacking context of when they knocked on the door, they said I was under arrest. They come in, begin to question me without reading my Miranda rights.
I'm getting all that. What, Ms. Beasley, what's your response?
Your Honor, I have told him that it's not the matter for a motion to dismiss because he doesn't agree with what the evidence is, or that a witness, he feels that they've lied. That's not something that I can do on a motion to dismiss.
Hush.
He was.
You're not testifying right now.
Again, I've asked for context and I don't receive it when I ask.
I'm getting context right now. I'm the one that she's talking to right now.
He has asked for me to write to him to tell him about his case. It's not typically what I do. So I set up phone appointments for him. They always have the option to come into the office. We've had multiple phone appointments, Your Honor. When he was in jail, I met with him several times. I don't think I've ever shrugged my shoulders and told him it is what it is, but these cases do take a while to resolve. I've tried to explain to him that I can't make the state dismiss the case. I can't make the state give him any particular offer. I can't.
I've heard of that. It is what it is. If a witness is lying, your option is to go to trial. That's the option.
But she couldn't explain that, sir.
That's a jury question, whether she's lying or not, or where he's lying or not.
The police know she lied. Everybody knows she
It
lied.
doesn't matter. That's not a basis for a motion to dismiss.
Why is
That's
one?
not a basis to.
This moment is wild. He's upset that his attorney contacted him too early in the morning, but the judge sees it as the attorney working hard. This clash shows how differently clients and lawyers can view the same situation. What do you think? Is 7:30 a.m. too early, or just a dedicated lawyer doing her job?
For me to appoint you another attorney, so I'm going to deny your motion to discharge your attorney.
Sir, she contacted me at 7:30 in the morning. That's not appropriate either.
Who?
Miss Beasley. 7:30 a.m. is when she decides to
I
call
would
me.
love for if I had an attorney, if they got up then at 7:30 in the morning and contacted me. My gosh, she's at work and she contacted you. So I'm denying your motion to appoint counsel. You can represent yourself or you can go hire an attorney. You're out of custody. That's up to you, but you've got Ms. Beasley. We need to set this for another court date.
Yes, Your Honor, the depositions are
I'm
done.
going to find that Ms. Beasley is competent in her representation. Just because you don't agree with her is not a
She
reason.
can't answer the questions for review of the
Listen, I'm
third
not arguing
party,
with you
sir.
anymore.
I'm asking my,
Listen, hush. I'm not arguing with you anymore.
I don't want to argue, sir. I just want to ask you one question.
I'm not answering any questions. That's it. We need to set it for trial.
He's set for pretrial July the 15th. I do need for him to listen to those deposition audios that we've got.
Okay.
So I don't know if he wants to come into the office and make an appointment with an investigator to do that. We did have some issues before.
We'll just leave it on that pretrial, July 15th at 1:30. We'll see you then, sir.
And just when you think the courtroom energy might calm down, nope. Another defendant steps in with almost the exact same complaint. This is turning into a full lineup of people firing their lawyers, and the judge is definitely running out of patience.
Yes, ma'am.
And Judge, the one I have before you this morning is a similar posture to the one Ms. Beasley just had at State of Florida versus Joshua Smith. Calm down, Mr. Smith. Your Honor, Mr. Smith has filed a number of pro se pleadings with the court. The problem is he's not representing himself, so the court hasn't been able to address those. He is requesting the court appoint him a fifth lawyer. As you recall, there was a public defender, the Regional Conflict Office, Jonathan Dingus, unfortunately passed away. And now my office, as well as a private investigator, Dan Estes. So I will step aside and allow Mr. Smith to argue why a fifth lawyer should be assigned to the case.
Raise your right hand. Solemnly swear the testimony you're about to give the truth, the truth, so help you God.
Yes, ma'am.
Mr. Smith, you may go forward.
Yes, sir. Thank you, Judge. First, I was like, start out, I believe the lack of attention to his, or to this deficiency in the preparation for depositions and applying the Florida statutes has greatly undermined the future outcome of my trial. The mere fact that my counsel has wrote a letter, which should be attached to the evidence, shows that my counsel hasn't applied the factual evidence from depositions to the body cam footage, as well as him advising me that if I paid an attorney, I could get a good representation and a suppression motion. Shows his lack of commitment to his client, to this particular case. The statement alone depletes the barrier of trust in my counsel. It appears that my counsel is biased towards either me or this particular case in general by the clear ignoring of the facts of evidence. Your Honor, I have asked my attorney multiple times. My wife has copies of emails where she's emailed him for evidence to obtain before depositions so we could do a proper deposition because to my understanding, there is no CAD calls. And I happen to know these officers were technically out of jurisdiction when they stopped my car. And I asked, can we please get a CAD call so we can contradict the jurisdictional violations and the other problems in the case? We haven't got that. We to my knowledge, it still doesn't exist. There's other things I've asked. We filed a Brady demand back in, I think it was November, and we waited till after depositions to file a compel motion. So I feel like my due process rights have been violated because how can you properly prepare for depositions if you don't have the evidence that you want to attack? for instance, we've got the body cams after, or we got the, we got the supposed video of the controlled buy that was supposedly in the affidavit stated was caught on recording selling a suspected 14 grams of methamphetamines. If you review the controlled buy footage, it doesn't show me, it doesn't show my vehicle, it doesn't show my voice or anything like that. These are things that could have been addressed in depositions and on a counter argument, especially the traffic stop, because the body cams say they stopped me for this incident, and then in depositions they change and say, oh, well, we stopped it for this, but there's no factual evidence saying this. And then you said you reviewed my car at the restaurant at 10 p.m., but you pulled me over at 11:32 p.m.
Mr. Saline, your response.
Sure, Your Honor.
And I reviewed the motion and I think placed on, but if you want to go ahead and respond to.
Oh, sure, Your Honor. The discovery, as you may recall, we just had a motion to compel at our last time before you, and Mr. Sullivan stated to the court that we have everything in the case file. In fairness to Mr. Sullivan, sometimes even the state doesn't have everything provided to them by law enforcement. It regularly comes up during depositions. Oh, you didn't get a copy of that report, or, oh, I didn't enter that into whatever. So the discovery items, I think we already addressed at the last court date. The not filing a motion to suppress, that's easy because no one in their right mind would file a motion to suppress when you haven't completed all your depositions. We still have a deposition of former investigator Raymond McNeil. He was scheduled April 22nd and served by the sheriff's office, but did not show up. He's been rescheduled to be deposed in August. There's no one going to trial before deposition occurs. There was a motion to continue the trial filed June the 4th. I'm trying to think what else was just put together as far as any type of jurisdictional issue. If he read the deposition transcripts, he already knows the answer to that situation. We've acquired everything that's been asked of us, including the file that Mr. Dingus had, which does not contain most of the items that Mr. Smith indicated Mr. Dingus possessed. So, I mean, I'm happy to answer anything else, but quite honestly, Judge, I think you have a couple of things. One, Mr. Sullivan thanks you for giving your trial strategy to him by sharing the letter. But I think you have an individual who wants to represent himself, but wants another bite at the apple for appeal purposes by saying he had an attorney. That's evidenced by all the pleadings that have been filed. I also think that this is difficult when reality sets in.
This is the real pressure point, a possible 25-year plea deal, with the threat of a much harsher sentence if the habitual offender enhancement kicks in. No wonder the defendant is desperate for a new attorney. He's staring down a potential life.
The plea offers the 25 years. Mr. Sullivan's let it be known that he will file pursuit of habitual felony offender and ask you to give basically a life sentence. And so lo and behold, as predicted, a Nelson motion comes forward. So I have no problem if he gets a 5th or 6th or 7th lawyer, as long as the record's clear that, much like the first 3, we've done everything that's been asked by the court, including Dan Estes, who's not here, but our private investigator, my God, was there even yesterday morning, despite this motion pending.
Investigator has definitely did his job.
All right, I am going to find that Mr. Saline has done what he's supposed to do, and he's provided competent representation. I'm going to deny your motion for conflict-free counsel. There is a motion to continue the August 4th trial. Does the state have any objection?
Was it just to do the deposition?
Deposition, and then he has
Because
a motion to suppress. He wants
if I can get ready to come in before then, can we leave it for that August date?
Yeah, I mean, I'll file the motion to suppress like Anders v.
So I'd like to leave it set for now, for that August trial date, and
We'll leave it, and we'll set it for July 22nd at 9 o'clock for any motions and trial matters.
Okay.
Yes, sir.
I'm fine with, I understand that. There's critical parts in it, like for instance, the CAD call. I would like a copy of the CAD
I
report.
can't, I'm not, that's not up for me. I've already made all the rulings I'm gonna rule, okay? And Mr. Saline's heard what you wanted, okay?
Yes, sir.
All right, we'll see you then.
Thank you, Your Honor.
Have a good day.